so much for
Thank you.
coming.
My pleasure. Thank you. Thank you. Thank you. Then came early 90s where we had economic reforms. We were in a serious financial problem as a country. We had hardly 2 weeks foreign exchange available to us, and if there were no steps taken for the purpose of opening up the economy, we would have gone like a banana republic. We would have had financial, I won't use the word bankruptcy, but there would have been a serious default in repayment of foreign currency loan taken by the sovereign of India. So 1990 onwards, there have been changes in economic policies, but the law did not really move forward on keeping pace with the economic changes. In the last 15 years, however, there have been significant amendments or significant changes in the field of commercial laws. There are about 9 or 10 laws which are material from this perspective. I'll take 2-3 minutes on each law, explain as to how the law has changed and what it has changed. The first, Companies Act 2013. We had a Companies Act of the year 1956. 1956 Act continued for almost 60 years. That Act was enacted at the time when the government of India believed in socialism, believed in license Raj, believed that profit is a dirty word and whoever makes money must be guilty of something. From that belief, we turned the corner and we found that unless you develop business, unless you develop industry, unless institutions, something was being handled by High Court, something was being handled by Company Law Board, something was being handled by the central government, something was being handled by Registrar of Companies, and there was a chaos and confusion. Now, National Company Law Tribunal is set up. It is the tribunal which undertakes and takes up every litigation under the Companies Act. It has wide powers. It's a specialized body. And it gives opportunity to all professionals to go and argue, including company secretaries, cost accountants, chartered accountants. But then it is this provision which has opened, therefore, a vista of the litigation and the practice. So Companies Act 2013 would be one major change in the field of commercial litigation. To that and connected therewith is the next piece of legislation, and that's Insolvency and Bankruptcy Code 2016. Under the old Companies Act, you can take a company to winding up. Winding up would take ages. But more important was, so long as company is not taken to winding up, or so long as winding up does not begin, the old management which brought the company to financial ruin, which created a situation whereby the company's financial resources are exhausted, individuals who have stood as guarantors for the company and otherwise. We have seen company being taken to winding up. Have you ever heard of an individual being taken for insolvency? In my career of more than 4 decades, I have never seen a person, individual, being declared as insolvent. That's never done because of procedural problems. Nobody takes the steps. Now under IBC, if you find that a company has failed, guarantor has failed, you can start taking steps for getting insolvency against an individual also. Which means now there are ways and means to start recovering the money as quickly as possible. IBC has resulted into significant amount being recovered over a period of time. Home buyers are also given advantage under IBC, and therefore this is one piece of legislation which has changed the whole spectrum of the commercial laws in the country. The next major piece of legislation, Goods and Service Tax 2017. We had variety of tax laws, and the variety of tax laws were also being enacted and implemented both by center and the states, where they may not see eye to eye. Excise Act, for example, was central act, but Sales Tax Act or the VAT Act was under the concurrent list. So each central government would have GST, CST, Central Sales Tax, or VAT on interstate goods movement. Each state would have its own rate of tax. If goods are manufactured and sold in Gujarat, let us say they may have rate of tax of 6%, but the same goods are manufactured and sold in Maharashtra, rate of tax may be 2% or 8%. Or if they are manufactured in Himachal Pradesh, the same goods may have rate of tax of 2% or 1%. So there was no uniformity in the matter of tax laws. There were also multiple tax laws. Excise duty, VAT, old sales tax, service tax. All these laws are now enveloped into one legislation, Goods and Service Tax, GST. It's a law which is being implemented across the country in a uniform manner. No state has a separate right, no state is at a disadvantage. So if rate of tax is, let's say 18%, 9% is retained by government, central government, 9% is given to the state government. If rate of tax is 12%, 6% versus 6% across the country. So irrespective of where you are manufacturing, irrespective of where you are selling, it is possible to have the same rate of tax. Therefore, there is simplicity, there is transparency, there is compliance. This law has therefore, in a way, significantly improved tax collection. There are problems, there are issues. There is always a feeling that it should be administered better. I am not therefore saying that this is administered in the best way. But like every law, there is always a possibility of improvement. But we are on principle. Principle being, should we or should we not have GST? All political parties agree that this is a fine move on the part of the government to bring in GST law. It is this piece of legislation, as I said, which has, so to say, unified different states of the union, significantly amended. There was no time frame within which an arbitration has to be concluded. Now, a time frame is fixed, 12 months, with a further extension of 6 months. And if there is no completion of arbitration within 18 months, you must go to the court and seek extension, which court may. And to that extent, one vacant area is now filled in. Consumer Protection Act is also amended in order to bring in the concept of rights available to consumers in relation to e-commerce. Special provisions are made for the purpose of enhancing the rights of the consumers. One major law again is in relation to builders, RERA, Real Estate Regulation and Development Act. This was one field where lot of people from lower class, lower middle class were taken for a ride. In India, if you look at the dream of a middle class person is, what is the dream? To have a house. We are short of space, we have too many people, and therefore availability of a good residential house is always a problem. Builders always have an upper hand, as a result of which, by and large, the consumers or allottees of the real estate property were fleeced, were taken for a ride. Even without having a piece of land, builder will start collecting money in the name of allotment. Even after allotment for years together, house may not be ready. Even after house is ready, it may not meet with the original expectations or promise. The construction may be defective. It was impossible for the home buyers to take any effective steps. In order that this problem is addressed, now we have a piece of legislation RERA, under which every builder must get his project of a particular size, which covers almost all housing projects, must be get registered there. They have to point out what they want to sell or what they would be selling. They would have to notify the allottees. Allottees have right to insist that they get allotment, the physical possession within prescribed time. If builder does not keep up the promise, they have right to take action against the builders. RERA has therefore, to that extent, ensured that there is some certainty and comfort to the home buyers, and they are not befooled or they are not cheated by the real estate developers. This is what, in my view, has been the significant changes in the field of law. There are also some changes in foreign direct investment policy, etc. But that's not a matter of legislation, that's a matter of policy. But effectively, attempts are being made to ensure that monies can come to India easily and foreign investors are not scared away from making investment over here. So that takes me to the conclusion. What is it that we can now look forward? Law is good not in making, that obviously has to be there. Law is good as it is good in implementation. So obviously there will have to be steps to ensure that it is implemented properly. Let me give you one example. Commercial Courts Act, when it started, was started with a big bang. Only few courts were there, only 3 courts were there in the state of Gujarat. Expert judges were put in and they were doing excellent job. Now there are commercial courts across the state, and even small litigation in the field of commercial dispute of more than, I think, 3 lakh is transferred to that court. So again, there is a backlog there. Originally it was meant to have only big matters, now everything goes there. So there are problems at the stage of implementation, but then as lawyers we need to take law as it is made available to us. When you go in the actual field, you will have to study the law as they are. And therefore, let me go back to where I started. Your interesting and bright challenges ahead. Those of you who are keen to come in this particular field, namely commercial laws, please take it from me. It's evolving even now. What is today will not be there after 5 years. It was not there 5 years back. But then it is something which you can look forward, and I'm sure you will have a great time in the practice. With this, let me end by giving only one piece of advice. I'm asked at times, how do you improve both knowledge, practice, or understanding of law? You are all fortunate that almost all major court matters or court proceedings are available online. Gujarat High Court is online since last 3 years, 4 years. Supreme Court also, you can access any Supreme Court courtroom. You are not permitted to speak, but you can certainly enter any courtroom virtually. Many high courts are now available to be seen on YouTube. My advice is, if you are free, open computer, don't start with Netflix, at least during court hours. Don't go for Prime. Go to courtroom. I'm sure sometimes you will get as much entertainment there as you will get on Netflix also, but I'm sure you will also end up learning a lot. It is not correct to say that unless you know the facts, you will not understand what's happening. Because I'm sure whoever is arguing will be giving some facts, will be discussing law. See how matters are argued. See how top class lawyers put across their case, how they deal with the judges. And I'm sure you will be able to understand the nitty-gritty of the judicial system, which is ultimately what you are looking for. Thank you very much for enabling me to share some of my thoughts. The floor is now open to all of you if you have questions.
Morning, sir.
Good morning.
For your insights on the topic that you have spoken. My question is this wise, with respect to IBC, as you mentioned that the liquidator, the resolution professionals, they charge handsomely. That is their motivation and that is their incentive. But sir, in some cases we have seen that the people who go for liquidation, the creditors, they are entitled to some amount of money, and more than half of it is then taken by the liquidators, the resolution professionals. So then, how does it work for the best interest of the creditors? And should there be some mechanism that only some proportionate amount should be given to the liquidator, the resolution professional?
Okay. See, it's not as if liquidator has a right to recover whatever he has. The amount of fees payable to him is prescribed in the schedule. Number one. Number two, liquidator does not act like a monarch or like a czar. Liquidator acts under the instructions of the creditors. So, if it is found, and there are instances where it is found that liquidator is not acting bona fide, it's always open to the body of creditors to decide to change the liquidator. You can make a complaint to IBBI, the board, which approves appointment of liquidator. You can make a complaint to NCLT. And if it is found that liquidator is misusing his position, then certainly necessary steps, including disciplinary proceedings, can be taken against him. But let's say company is worth rupees 20 crore, hypothetically. You are not going to realize more than rupees 20 crore. Even if the total amount payable to creditor is rupees 200 crore, because amount payable is rupees 200 crore, you are not going to realize more. Ultimately, realization is going to be rupees 20 crore. So what you need to see is not what is the amount that I as creditor am getting. Because you as creditor would get what is the amount available with the company. What needs to be seen is whether the liquidator is taking steps to realize what I am entitled to, and in the process not taking away more money than what is entitled to. So yes, there are instances where liquidator has not acted bona fide, but then they are corrected. IBBI and NCLT both are conscious of it, and if it is found he has not acted bona fide, he can be even removed, suspended, removed, penalized by the IBBI. Thank you.
Hello, sir.
Yeah.
So, sir, actually, I'm a final year IPR honors student, and I have done multiple internship in IPR field, and even currently I'm doing IPR internship, running internship. So, as you stated, we should not generalize our field. First, in initial years, we have to focus in all the fields in law. So now, what should I do? Like, should I transform my internship in other
No,
fields or?
no. You are right now at the stage of learning. You have chosen to learn a particular topic, a set of laws, more in a more detailed manner. Please do that. I am on stage 2. Once you finish your studies, you will go in the real world. Please do not start with a belief that if somebody comes to consult me in rent dispute, somebody comes to consult me on if I'm not getting money from Mr. A, what step do I take? You will say, oh, I will not look into it. In the initial years, keep mind open to entertain all legal issues, because your knowledge of other branches of law would be significantly helpful even in IPR. Assignment of trademark. Now, assignment is not a matter of the IPR, assignment is a matter of the law of contract or the breach of the infringement of a registered trademark or passing off action. Passing off is a matter of tort. Infringement is a matter of law as opposed to the law of tort. So you must know difference between tort, which is not a legislation, it's a common law, and a law, which is a codified law. Unless you are able to make good that difference, you might at times end up making a mistake. So, my advice is not to give up specialization. My advice is don't be so wedded to specialization that you keep your eyes closed on the rest of it. There are people who, young lawyers, just out of college, they come and meet me and say, sir, we would like to IBC specialist. We'll start coming to NCLT. I said, please don't do that. Attend NCLT, but also attend High Court, attend Civil Court. See what other laws are. Because it is not as if you can be specialist in one branch without being exposed to or without being broadly, generally available, generally knowing rest of the fields. That is what I was trying to say.
We'll take one last question.
Yeah, that's okay. We can take 2-3 more, no issue.
Good morning, sir.
Yeah.
As you have said, you are a CA and right now practicing law as a senior advocate. So after getting one of the finest degree of CA, what motivated you to pursue law?
Okay. I'll give a brief answer. My view was, especially in those days, a chartered accountant was either an auditor or a tax practitioner. It's today that chartered accountant has multiple opportunities. I became CA in the year 1981. None of you were born then. So at that time, there were only 2 possibilities. I didn't want to take up the issue of audit, because audit, I believed, is a negative function, find out fault of others. That's an audit. I never wanted to do that. I was interested only in the field of tax laws. And if I'm interested in the field of tax laws, why should I be wedded as a chartered accountant to lower fields? Because as a chartered accountant, you can't argue beyond a tribunal. If you want to argue in High Court or Supreme Court, you need to be a lawyer. And because I was keen to practice only in the field of tax laws and I wanted to practice only on the appellate side, I chose to be a lawyer. In fact, I had decided not to be a practicing chartered accountant after I finished my inter CA. But I thought, let me finish my CA in the mean. So I finished the CA, never got certificate of practice of chartered accountancy, because CA was then, in those days, 3.5 years, law was 3 years. So before I became chartered accountant, I was already a lawyer. So I took certificate of practice of a lawyer, practice as a lawyer from day one. I'm sharing this only in order to say that there are multiple reasons why a person chooses a particular profession or a particular way of life. Nothing is good or bad. It's all a matter of how you perceive your life to progress. So, because you happen to be a lawyer, it's not as if you are better than others or you are not as good as others. Do well in your profession, and I'm sure world is at your feet. Anything else? Then I will. Yes, please.
So I'm a faculty. This is on behalf of the students, and some students have been asking me. You have done your CA and then your law in parliament. Is it really a good idea that you should pursue some professional course apart from your? Most of the trend now is integrated law and management, BBLB or BLLB as we do. Should we also think something more other than that, or is it a good idea to focus on the law and?
My view is, today law has become far more complex, far more intense. In my days, we had Contract Act, Sale of Goods Act, Constitution of India, Criminal Procedure Code, IPC, some basic laws that were taught during the law college. And rest of the laws we only understood when we started practicing. Today, as students, you are exposed to a whole bouquet of laws which were not enacted 20 years back, 30 years back, like environmental laws. They were not there 30 years back. So, number one, the education in the field of law has become far more intense, which would require a student to devote time and energy far more than what we used to do in those days. Because I was doing CA, I am not advising anyone, but I am sharing a secret. I never went to law college because I was doing CA. No, I was gold medalist in law also. Not that I did not do well in law. I never went to the law college, though I got gold medal, but it was possible to study at home and do well. Today it is not possible. Today the course of law is extremely complicated, demanding, and it requires probably full-time attention of the law student. My view would be today, and secondly, in good old days or old days, good or bad, uh, law by itself was not offering so much to a law student that he would feel comfortable that after finishing law, I'll be doing good and therefore I don't need to study anything else. So other studies were also in a way a backup mechanism. Nowadays, with a law graduates having so many opportunities, getting good offers in big firms, having good practice possibilities, you don't really need that backup. Summary of what I'm saying is, if you can cope up with some extra course, please do that. Knowledge is always welcome. But please don't do it at the cost of your present studies, because this study is also extremely important. This practice of law, or this studies of law today, cannot be taken in a light-hearted manner, cannot be done in a casual manner. If you're looking forward to be employed by the big law firms, you need to shine out. You need to prove that you are worth the handsome salary of 15-20 lakh of rupees per annum to begin with. If you are required to do that, you need to focus on this profession, on these studies. If you are confident that even after doing that you have time and you would like to supplement your knowledge, please go ahead and do it. But don't do it in a manner so as to distract you, defocus you from the present studies. That's what I would advise. Thank you very much.
Thank you so much, sir, for
Welcome.
being here and enlightening us.
Welcome.
I am sure it was a very fruitful session for all of us present here. And on behalf of UWSL Karnavati University, we extend a warm
Thank you.
gratitude.
Thank you.
So much.
Thank you.
Thank you to everyone for
Thank
being
you.
here. Thank you.
Excellent. I find the university to be an excellent place of work. I find the students very curious about knowing the laws. I find them to be interactive, and I found that I had a great time. I wish all the students and the university all the best.